If a police officer questions you when you're not in custody and haven't yet been given Miranda warnings, and you simply choose to remain silent in response to an incriminating question, may a prosecutor later use that silence against you at a trial? The United States Supreme Court addressed this issue in Salinas v. Texas. Police officers suspected that Genovevo Salinas had committed 2 murders with a shotgun. Officers went to Salinas' home, where he agreed to turn over his shotgun and also to voluntarily accompany the officers to the police station for questioning. There, they interviewed him for approximately an hour. Salinas was not in custody, so the officers didn't read him Miranda warnings. For a majority of the interview, Salinas answered the lead officer's questions. However, when the officer asked Salinas whether his shotgun would match the shells recovered at the crime scene, Salinas refused to answer. Instead, he looked down to the floor, shuffled his feet, bit his bottom lip, and clenched his hands in his lap. Salinas remained silent for a few more seconds, but when the officer asked additional questions, Salinas answered. After developing additional evidence, the officers arrested Salinas, who was charged with murder. He pleaded not guilty and had a jury trial. Over his objection, the prosecutor questioned the interrogating officer about Salinas' silence in response to the officer's question about the shotgun. During closing arguments, the prosecutor argued to jurors that Salinas' decision to remain silent about the shotgun was evidence of his guilt. The jury convicted Salinas of murder. On appeal, the Texas Court of Appeals affirmed Salinas' conviction. On further appeal, the Texas Court of Criminal Appeals also affirmed. Salinas successfully petitioned the United States Supreme Court to review his case.